Ready to go.
Good afternoon, everybody, and thank you for joining us today for our webinar, which is presented by Collyer Bristow and CRMG. I'm Simon Lacey. I'll be your host for this afternoon. And my experience in this field is I spent 11 years working within information governance within the NHS, and then spent 4 years as information security policy manager at the Bank of England, which was a fascinating experience. I think the level of interest in our webinar today is a really good indication of the perceived complexity and the desire to increase awareness around the subject of mergers and acquisition, and particularly in relation to cybersecurity and data privacy risks. Before we get underway, we have some housekeeping here for you. Today's session will be 45 minutes long with a 15-minute Q&A session at the end. Please submit your questions through the Q&A panel at the bottom of your screen there on your Zoom console. It'd be great if you could send those through, so don't wait until the end before sending your question. Just if something comes into you, a thought comes to you, please ping that message down to us and we'll make sure they get routed into the speakers at the end. This session is being recorded and a copy will be sent out of that recording and the slides and any answers to questions after the event. During the webinar, we will be featuring a number of online polls. Please ensure that if you want to take part in those, which would be brilliant, can you make sure that your browser settings are appropriate and you're not blocking pop-ups? The better the engagement, the better those results will be. So that'd be really great if you were able to do that with us. I'd like to introduce our speakers today, and just realizing that the two speakers we've got lined up primarily have over 40 years experience in this subject matter. So I think that's a fantastic basis for our session today. So firstly, I would like to introduce Howard Ricklow of Collyer Bristow, who's a partner of some 22 years, specialising in privacy and GDPR. And if you look up Howard on LinkedIn, you will also see he's a freelance writer. So that's quite an interesting blend there of skills. Afternoon, Howard, how are you?
Very well, thank you. Good afternoon to you all.
Our second speaker will be Simon Rycroft, who is the co-founder and director of CRMG. Previously, Simon has held various cyber risk roles at PwC and also headed up the global consulting team at the Information Security Forum. Afternoon, Simon, how are you doing?
Oh, Simon, I'm very well indeed. Thanks. Really looking forward to the session.
Good, good, and great to have you here. And also supporting our two speakers during the Q&A session will be Sharon Fryer of Collyer Bristow. Sharon has been a partner for the past year, and am I right in saying, Sharon, it's coming up to your anniversary now?
Yes, that's right. It's certainly been an interesting year.
Well, hopefully it can be even more interesting this afternoon too. And Sharon specialises in corporate law. And finally, and by no means least, Mr. Nick Frost, who's also a co-founder and director of CRMG. Previously, Nick was also at PwC with Simon and headed up the global risk function. How are you doing, Nick?
I'm very well. Good, very well, thank you.
Good, good. I note from the photos we've got on screen here, there was an absence of COVID hair when we did those photos. Plenty of COVID hair on share show here. For those of you who, when you signed up, if you may recall, we had on our sign-up screen a case study, which we'll be using as our basis for today's conversation. I'm not going to read out this text verbatim because it's on screen and you can read it there, and I'll leave it there for a second for you. But I think there's a couple of points there I'd like to call out. The fact there's a natural synergy between the two organisations, Harry's Hardware and Handyman team. Again, very useful when there's a merger and acquisitions taking place. The founders are very much in control. Again, a very common theme when you have small and medium-sized businesses, and very much in control of how they spend their money and invest it into their business, which has been successful. That's such a common scenario when it comes to this kind of work that we're looking at today, and provides really useful context. So before we go hand over to Howard as our first speaker, the first of our poll questions will be arriving on your screen any second now. When involved in the buying or selling of a business, have you previously given serious thought to the cyber risks and data protection issues involved? If you're able to pick one of those two options there, please don't overthink them. Just go with what your gut feeling is on those. Just another second more, and then we'll move on to our first speaker. Okay, let's have a look at those results. So 77% of those who voted said they have had a serious thought, and 23% no. Howard, what do you make of that as a starting for your session there? 77% have had serious thought about cyber and privacy risk.
Yeah, I think most people now are cognizant of data protection issues because GDPR has been with us for 2 years now. And there was much publicity and much excitement and worry. I don't think there was anybody that wasn't aware of GDPR. Cybersecurity, I would think it depends on the nature of the organization and the nature of the business. So I'm pleased that the greater majority of people that voted are cognizant of the two areas. And I hope that what I'm going to talk about will be of interest to everyone.
Yeah, I think that's a great point there, Howard, about GDPR. I'm sure has been a big driver of this increased awareness, and I think that's probably reflected in the poll. I'm sure if we'd asked that 2 years ago, we may have had a different slant on that. Anyway, I'd like to hand over to you now, Howard. So please take it away.
Thank you. Good afternoon, everybody. I'm going to talk about the transaction process from the legal perspective, how a typical M&A works in the confined time we've got to discuss it, but focusing on cybersecurity and data privacy in the transaction. So if we move to my first slide, please. So what is the role of the respective lawyer in the transaction? The 2 bullet points sum it up really. There's a lot more to it, but in essence, carrying out a due diligence, that's on behalf of the purchaser, Harry's Hardware, and the lawyers for Harry's Hardware will be assisting and driving that process. The lawyers for the target and demand team will be cooperating in answering questions under the due diligence. And the second role is preparing and agreeing the share purchase agreement and the disclosure letter. So let's have a look first at the due diligence. What is the purpose of it? Well, it's very much an American term. It's an inquiry. It's an inquiry by the prospective purchaser to gather information on the target prior to a contractual commitment. The purchaser will want to know as much as they can about the target's business. The due diligence process involves financial, legal, commercial inquiries, so that the purchaser, who will probably have an idea of the business they're buying in terms of the nature of the business, but to uncover anything that may not be so good, get the skeletons out of the closet and to consider whether or not it wishes to proceed with the acquisition if things look not as great as they'd hoped, but if they do, upon what terms and price. So let's move to the next slide. And we've got a poll question first. So here's the question to everyone. To what extent are you familiar with the sorts of questions that you should be asking during the due diligence process? If you could please vote. Well, that's an interesting division. I think somewhat familiar is probably my experience with clients. The fact is that the due diligence process involves every aspect really of the target's business. So the accountants generally will be doing financial due diligence, which will ask about creditors, debtors, tax, liabilities, balance sheets, all the things that accountants will ask questions on the business. On the legal side, it will range for everything from real estate, questions about what properties there are. We're talking about a retail business here, so there'll be lots of questions on the leases for the for handyman. To the extent they've got offices, they probably won't have retail premises, but they will have offices. There will be questions on their creditors, their liabilities, their intellectual property, but we're focusing on the IP aspects, really, the IT aspects, the cybersecurity and the data protection. So let's look at the next slide as to the objectives. So Harry's Hardware solicitors are going to be looking at what risks or issues arise under this due diligence, which may affect the position to decide whether to proceed or not, or how to negotiate the price, but also to enable specific warranties and indemnities to be included. And I'll come to what warranties and indemnities are. So the seller's role, the handyman team, their lawyers and accountants and others involved in the process to assist in the preparation of the disclosure process against the warranties. Well, initially they'll be involved in the answers to the due diligence questions, and then they'll be involved in the disclosure process against the warranties. So if we move to the next slide, we're waiting for that to come up. Here we are. As I said, we're focusing on the IT, cybersecurity and data processing due diligence. There are many other areas, as I've mentioned, but Harry's Hardware's team will be asking for details of cybersecurity, data loss or unauthorized access, cybersecurity vulnerabilities, threats and attacks. That's on the cybersecurity side. They'll also be asking for details regarding data processing policies, procedures, compliance, breaches and claims. So there'll be many pages of questions on all of this. Typically, depending on the business, some of the answers may not be quickly forthcoming. I should stress that often the share purchase agreement, and I'm going to come to the warranties shortly, but often the share purchase agreement, which will have been prepared by Harry's Hardware's team, will have been sent out, containing the numerous warranties and indemnities. It would have been sent out probably before many of the answers to the due diligence questionnaire have come through. But what the handyman team and the solicitors need to consider in relation to this due diligence question is, yeah, we can still stay on that side, which is the extent to which they can disclose personal data and confidential information. With regard to confidential information, pretty commonly there will be a non-disclosure agreement entered into by handyman team and Harry's Hardware solicitors, under which the purchaser team will undertake that they're not going to disclose confidential information or be only using it for the purposes of the transaction. But there's also the disclosure of personal data, and the handyman team's lawyers will be looking at to what extent personal data we have, which could be customers, could be suppliers, all sorts of individuals whose personal data is being processed by handyman team, to what extent they are able to disclose this. They'll need to look at their privacy policies, their data sharing agreements, and see what they can or can't do, whether they need to anonymize, particularly in terms of employees. So they'll have a look at that process. But also they'll need to look at whether they need to undertake what's called a data protection impact assessment, and that's under GDPR. And that's where, if there's a high risk that this transaction or post-transaction, because there are going to be new technologies or mergers of databases, if there's a high risk to data subjects that their personal data be compromised, then they need to undertake this. I would say it's not only when there's high risk, although that's what GDPR says. I would say, as you'll find out when Simon speaks later about one particular hotel acquisition where something went badly wrong, that they should be, if not formally undertaking a data protection impact assessment, should be looking at what could happen when the two businesses merge and there are transfers of personal data and what cyber risk is involved. So we can turn to the next slide, which is going to look at what are warranties and indemnities. So warranties are a series of statements which the sellers, which will be the shareholders of Andy Mann's team, are asked to give. Typically, they will be drafted by the purchaser's solicitors, and they're basically a series of statements. Statements like, we own all the properties for the offices we work out of. We own all the intellectual property. We have necessary trademarks registered. Our creditors are no higher than we've said. Our debtors are no lower than we've said. Our accounts have always been submitted on time. We've always paid our tax on time. We're not being sued, and so on and so forth. So there are a series of statements which they warrant to be true. And as the due diligence process goes on, the purchaser's solicitors, once they see the answers to the due diligence process, which may be unsatisfactory or may disclose particular areas of concern, then the purchaser's solicitors are likely to ask for specific warranties, which have arisen because of the due diligence process. Now, indemnities are similar, but they're not a series of promises. They are provisions which would require the Andy Mann team's shareholders to compensate Harry's Hardware for any losses they suffer as a result of circumstances in question. So I won't dwell on the difference in effect between the two and what they actually mean. But one is a promise, and you'd have to, in essence, prove that the promise wasn't true, whereas the indemnity is a statement, which is to say, typically, let's think of data protection, where there's some uncertainty because there's potential prosecution by the Information Commissioner's Office or potential legal case by data subjects when there's been a compromise of data, and data subjects are threatening to sue Andy Mann's team. So the purchaser's solicitors will say, well, we want an indemnity because we're going to own the company. You're not going to be in the target anymore. You're gone. So if anyone's going to be prosecuted, it's going to be us as the owners of the company, or sued by these data subjects. So we want an indemnity whereby if we do have to pay out because we've been fined by the Information Commissioner's Office or been sued for damages, that you'll compensate us, and that's what an indemnity is. Very important to stress how the due diligence process must work, and it's very much a team operation. It's not just the lawyers acting for the purchasers. It will be others in the team. It will be accountants, but it will be ideally cyber risk specialists, because the lawyers can draft the warranties and indeed indemnities, but the lawyers are not experts in cybersecurity. They're not the ones to see the weak link in the armory. They can ask the questions, but it really needs experts to go in and start sort of interrogating the systems. So very much a team sport here. As I said, the due diligence is critically important to enable Harry's Hardware to assess the risk of buying the company and whether to pull out or seek a reduction of the purchase price, which is not uncommon. And whilst warranties and indemnities are critical to the process, they're not a substitute for a full due diligence investigation, because the purchasers really do not want to have to sue for breach of warranty or enforce an indemnity. In particular, as is often the case, members of the Andy Mann team, maybe Andy Mann himself and his management team, are going to be kept on to ensure the smooth transition. Maybe they're going to stay on as consultants. So the last thing you want post-merger is that the guys that are going to be working with you are being sued. So everybody would much sooner that the due diligence process were uncovering things that needed to be covered and where they could be dealt with without resort to having legal action. So we can move on to the next slide. What is disclosure? Well, I said what warranties are. They're a series of promises. rather generally than amending warranties, because they can't say there has been no cyber breaches or no data breaches. Where the warranties are tinkered with, there will be disclosures against the warranties. So, for instance, if the warranty says there have been no action by the ICO or investigation against you for any breaches of GDPR, if there have been investigations, then the disclosure would say that the ICO is currently investigating a data breach which occurred last year. Similarly with cyber risk, if a typical question is, has your system been compromised? Has there been hacking? Has there been phishing? And you've asked for a warranty confirming that. Well, if there have been such incidents, then the disclosures will say on this date something occurred, it's still under investigation. And there can be a, I mean, the disclosure letter is not normally negotiated as such, but it does allow the purchaser to take a view on what may need to be done prior to completion or preparing themselves for after completion, but also whether the purchase price needs to be negotiated. As you can see, the disclosure letter often arrives very late in the process. There's generally a lot of pressure on lawyers, accountants, and indeed cyber people to get the thing done. And people can get tired. It can be quite a lengthy process. So it's very, very important to get the due diligence done effectively, expeditiously, so that any skeletons in the closet are identified long before the disclosure letter reveals them, if possible. So I think that just about closes my part for now. It's been a bit of a gallop through it. Happy to expand upon anything, answer anything in the Q&As that people want to discuss further. And I'll turn back to Simon now for the next part.
Thank you, Howard. That was a really interesting slot there, and as you say, there's a lot of ground to cover there. There was just one thing I'd like to pick up, if I may. You've mentioned on the one of your slides about the concept of threats, and something I've seen in my experience with particularly small and medium-sized business. There's almost a bit of a finger in the air type approach to risk management. So people will say, well, okay, likelihood versus impact. And it will be a gut feel rather than some kind of process very often. So just to be clear in my own mind here, what you're saying is if you're doing those kind of risk assessments, actually there has to be something in terms of your threats and vulnerabilities. There's almost a legal wrapper around that. Is that correct? Have I understood that correctly, Howard?
Well, the warranties, I mean, they can be, they're evolving, particularly vis-a-vis IT. Whereas a typical warranty as regards intellectual property, do you use trademark? You know, in the due diligence process, you'd have asked, have you got any trademarks registered? And they'll say yes, and there'll be a warranty saying all our trademark registrations are up to date and fees have all been paid, none have expired. With IT and cyber risk, because hackers become more and more sophisticated, the warranties need to be nuanced. Indemnities if they're appropriate, but yes, the idea will be that the target's solicitors and their own cyber team will need to look carefully at their history, look carefully at their systems, because the owners, the shareholders in Andyman team are going to be warranting that something is true, disclosing against that if they can't give an unqualified warranty. But they can't fib without risk because they can be sued and it can be a very nasty business. So, and normally you've got 6 years. It depends how it's negotiated. The seller's solicitors will try and say, well, you've got less time to sue. The purchaser will want to know that if something's uncovered later, it may be much later, that they've got a longer period to take action. So, the seller's team, their legal team, and indeed their cyber team, and anybody else involved in the sale will be saying, think carefully about how you answer due diligence and think carefully about these warranties, because you may be well counting the money, your many millions you're making on it, but when that solicitor's letter comes through the door saying we're suing you for breach of warranty, it's very unpleasant.
Okay, that's great. Thanks very much, Howard. That's fantastic. Now, moving on to our second speaker. Please, in the meantime, keep the questions coming in. If there's anything that's entering your head right now you'd like us to talk about in the Q&A session, by all means, send that down to us. We've had a couple come in already so far. Simon Rycroft, if I may pass over to you now.
Thank you very much. So if we move on to the first slide, thank you. So bearing in mind, if you move on one more slide, please, Simon. So bearing in mind the M&A process that Howard's just set out for us, what I want to cover is the importance of getting assurance rather, that the target organization's approach to cybersecurity and cyber risk is genuinely fit for purpose. The due diligence activity that Howard described, it can't be merely a procedural tick box based exercise. It can't be a ritual dance, as Howard sometimes describes it, because when things go wrong, they can go really wrong. So the case in point that Howard mentioned a moment ago, Marriott and Starwood, they merged. Starwood essentially hadn't addressed a systems breach from back in 2014. It went undetected, didn't get picked up by the due diligence process. Then afterwards, of course, you get a potential exposure of 339 million guest records, and the Information Commissioner's Office in the UK notifies an intent to fine of 99 million quid. And so it's big potential exposure here we're talking about, and it's not just financial exposure or a hefty fine. The reputational impact of a cyber breach, well, that could be existential. And as a consequence, actually boards are pretty well attuned these days to the need to manage cyber risk. Let's move on a slide. And I think, Simon, we've got another poll question, haven't we? Yes, we have. Okay. So are you confident that a typical due diligence process would pick up cyber issues? If you just have a quick crack at answering that one for us. Yes, no, or I'm not sure. That would be great, just to give us a little bit of context. And then I'll get cracking with the remainder of my content share. Right. So let's see the results. Okay, but that's not surprising. Yeah. Okay. In one sense, it's assuring because it is a woolly area for a lot of organisations, but at the same time, it just does really highlight that this is an area that's gone massively under-detected and handled in a sense in a lot of previous historical M&A situations, at least. So that's why we're here talking about this stuff. Okay, so let's move on to the next slide, please, Simon. So let's get back to our acquisition scenario. We've got Harry's Hardware. They're a high-profile national chain, sort of large DIY store you might find sitting on a retail park outside an urban hub. Due to all sorts of potential synergies, then they've acquired the Andyman team. They're a bit less mature. They're still national. They don't really focus on cybersecurity so much as the Harry's Hardware have done. They're not really focused on their housekeeping as well as they might have done. 3 weeks after acquisition goes through, the Andyman team's legacy main customer database is breached. Details of that database are published for sale on the dark web. Ouch. The wider context here is that any merger or acquisition involving even vaguely technically mature organizations, it's potentially fertile breeding ground for cyber mayhem. And we've seen that time and time again. At the best of times, any organization can be targeted. And we've got some examples just here on the screen here. This isn't a technical presentation, by the way, and I won't run through those elements in detail. But the point is that, number one, there are bad guys out there waiting to pounce, performing reconnaissance, probing for vulnerabilities all the time. As an example, at the moment, we know from talking to our technical partners that VPN servers particularly are receiving particular attention from the bad guys. And the obvious reason for that is that everyone's working from home at the moment. Number two, you've got staff, and sometimes they just make mistakes and they don't follow the guidance you set, and they don't change their passwords maybe in line with set rules and so on. And that can potentially cause a lot of damage too. So all of this is true of any business, but the M&A setting in itself has got the potential to amplify exposure due to a range of factors, and we've got some on the right-hand side of the slide here. If you've got a high-profile merger on your hands, the respective parties will just be more attractive as a potential cyber target. That's just the reality of media exposure and of the way in which people in mal space, the cyber baddies, would operate and respond. The two organisations might have massively divergent approaches to their understanding of cyber risk and how they've chosen to handle it. In this case, the Andyman team potentially has not done its job well enough in protecting its critical customer database. It hasn't protected data at rest. It potentially means you've got an overall imbalance in cyber exposure between the two parties. And if one party hasn't mapped out its information assets, if it doesn't know where its what we call mission critical assets or crown jewels are, in this case the customer database, if it doesn't undertake some sort of information risk assessment as a matter of course, if it hasn't pinpointed everywhere that it's handling personal data adequately, then it's very likely that there's a future cyber related problem festering away. And linked with that point, if the parties have got quite different approaches overall, in terms of their risk appetite at the top, how that translates into operational risk management, it can be different. You can get an imbalance there that raises issues. So, in industry disruptors, as we might call them, organizations like Uber that often geared around new technologies, they're often far more willing to take the odd risk here and there when it comes to pushing products and updates out to market in a way that a traditional organization just might not be comfortable with. Other factors, incompatible technologies, not necessarily a cyber risk issue per se, but what we do know that is legacy, often bespoke systems that were built to a customer's requirements maybe 15 years ago, they quite often will not happily connect to another organization's systems, or even to the internet for that matter, without quite a lot of pain and quite often without cyber vulnerability along the way. And there was obviously a bit of that going on, was probably in the Marriott and Starwood case. And then you've got the people dimension. If you've got a poor culture when it comes to how people act on their responsibilities to protect information, you try to marry that up with an organization where that culture on the corresponding side is quite strong. Again, you've got a mismatch and a potential problem. There may have been a bit of that going on with Marriott and Starwood as well. Supply chain. The big challenge here is that there is potentially significant hidden cyber risk in an organization's supply chain. And I'll come on to that in a little while. And lastly, unless the M&A process itself, unless that due diligence activity is probing enough to pick up the types of issues that we're talking about here, it won't necessarily identify residual latent cyber risk issues that then come back to bite you in the collective posterior, post-merger or acquisition. So that's why M&A in particular can cast the spotlight on cyber risk issues. But for our hapless newly merged organization, it's too late. So how do we go about handling this? So let's move on to the next slide. I think we've got it built. There we go. So in an ideal world, we would advise organizations to adopt a prevent, detect, respond type strategy at the highest level. Conceptually, that's largely self-explanatory. You try to prevent nasty stuff happening to you. But if it does affect you, then it's really important to detect that it's happened really quickly and respond swiftly. And in a way, of course, that minimizes the business impact as much as possible. Now, in this case, it's a bit late for that because some nefarious individual in the cyberspace has already made off with Andy Mann's team's customer database. So we're going to have to mix things up a little bit. So let's just activate the build on the slide. So in this case, but this case only, we hope, we've got to start with detect to make sure we know that something's happened, and then we'll move on to how we respond to that. And then we'll come on to, well, what should we have done about it in the first place to prevent it? What would we really be looking for in an M&A setting in terms of indicators that information risk has either been taken seriously or not? So let's start with detect and move on a slide. It's really not great to be informed by the outside world that you've been the victim of a cyber event. Now, whether that's from an unhappy customer, whether it's from the media, whether it's from the police, or even the regulator in the UK, the Information Commissioner's Office, not good. I mean, aside from the fact that the longer a breach is left festering, the worse the operational impact is going to be, it's also where reputational impact particularly could be exacerbated. If the organisation is seen to be completely oblivious that it's been a target. So this is where having decent technical capabilities that can alert you that either a breach has occurred or is highly likely to occur imminently, that's really important. As I said, this isn't a technical presentation. Now, some organisations will have what's called a SOC capability, a Security Operations Centre, or some sorts of technologies in place. And this stuff isn't niche. These capabilities are quite mainstream, maybe with the exception for smaller organizations, things like late data loss prevention. But in an M&A scenario, you should expect to see evidence of this type of capability in place. Let's move on a slide. So we've detected that it's happened, ideally by in-house means, technical means. And from this point, you're going to have to respond swiftly and ideally swiftly recover. And this is going to involve a range of things. You'd expect some sort of fast assessment, either by in-house personnel or bringing in outside support swiftly to understand what's happened, to understand the potential extent of the breach, its implications both for the organisation itself, but also for customers and other third parties, such as suppliers. In some cases, of course, it may be that you need to notify your local, your regulator in your jurisdiction, in the case of the ICO. For a very significant breach, you'd expect some sort of crisis management process to kick off at this stage. And that's likely to involve board level involvement. It could include things like liaison with the media and so on. It isn't a forensic investigation at this stage. It's too early for that. But you could describe it as a sort of a risk-based triage process. For example, you're likely to maybe see some sort of emergency fix or patch needed to be applied to the system in question. You might see even that the system needs to be taken down completely if the breach is very severe and the obvious route to fixing it isn't clear or can't be done very swiftly. For obvious reasons, though, at this stage, care has got to be taken to make sure that you're not riding roughshod over evidence that's likely to be required later on. So emergency fixes, for example, they need to be recorded. You'd expect to see evidence that they've been recorded, and that because they're only temporary, they need to be made good later on. You need to see evidence of that too. So the aim here at this stage is mitigating damage, but at the same time, of course, also fulfilling your obligatory, your regulatory obligations rather. And then you should expect to see evidence, of course, that all these activities taken place. And we've seen traditionally that organisations, as an example, are not good at applying consistent incident management practices. Incident reporting and recording, for example, in some businesses can be patchy, to say the least. And so this is something you should be looking for when evaluating a potential acquisition. I just want to mention the role of cyber insurance at this point, because most sizable organizations will have a form of cyber insurance in place these days, but a few things to bear in mind. Firstly, cyber risk in itself is tricky to price for the insurers. That means that insurers traditionally haven't been great also at understanding the extent of potential exposure and designing coverage accordingly. And secondly, an insured organization might have difficulty in assessing that its coverage is adequate. And one of the things that we do, for example, is we'll work with organizations to take a risk-based approach to assessing the adequacy of its insurance coverage from a cyber perspective. And another point on insurance, of course, is that it can compensate you with money. It can compensate you with some sort of financial recompense after the fact, but it will never do anything to restore your reputation. So it's so much better if these things do not happen in the first place. And the last piece on this slide, investigation. So for significant breaches, some sort of forensic investigation is likely to be required. This is going to require collaboration, collection of evidence from a variety of sources. Forensic analysts will look to corroborate different evidence from different sources. such as, just as an example, system logs, alerts, even evidence from individual staff, for example. And the integrity of that lot will need to be preserved, and you would expect to see evidence that it has been preserved if an organization is reporting that it has suffered a significant breach in the past. You should expect to see, a virtual paper trail on that lot, and the fact that the organization has taken notice of the outcomes and taken action accordingly. Let's move on a slide. So what would good look like then, in terms of, well, what would have prevented this lot in the first place? Technology, of course, has got a really important part to play, but a risk-based approach to cybersecurity governance in a sizable organization is going to be crucial. That's because unless you understand risk, unless you've identified threats, unless you've focused on most important systems and information assets, you've got an organization that's trying to boil the ocean, and that never ends well. So this slide shows you the sorts of arrangements you should look for evidence of. This is purely indicative, but a good cybersecurity or information security function, the two are largely interchangeable terms these days. It will be implementing specialist cybersecurity improvement projects in line with risk. It will be supporting regulatory compliance activity. It will be monitoring ongoing security activities to make sure they still remain fit for purpose, and reporting progress and key risk issues up to the board. It will be making sure that new systems coming online are secure. That's that little SDLC circle you see in the middle there. It stands for Systems Development Lifecycle. And it will be providing guidance to the business and to staff about how cybersecurity can be injected at the right places to both keep the business secure whilst not acting as a brake or holding the business back. But this piece on the right is really key, because this is what makes sure that there's adequate protection in place to keep the business safe while avoiding unnecessary ocean boiling. And so when we talk about risk assessment, we're talking about a process that does these things. And this is just an example. There are various different accepted methodologies and processes out there. So firstly, you need to look for evidence that there's been, at least for a critical system, you need to look for evidence that there's been a well-scoped risk assessment that's included all the right components. It needs to have involved the business. It's the business that identifies business impact. If we talk in information risk and cybersecurity, talk about the confidentiality, the integrity, the availability of information, and how important it is to protect those things. So we're saying that, what's the damage to the business potentially if those are to be compromised? And then you assess threats. And there are all sorts of different sources of threats that can provide structure to that activity. But basically, you need to understand what potential threats could this system be exposed to. And once you've done that, you can look at vulnerabilities. And that's largely about understanding the extent to which you are protecting your systems currently in the context of the threats that you've identified. Different things that you do, controls we call them, will have a different relevance in terms of mitigating different types of threat. And then once you've done all that, you'll run that lot through some sort of risk calculation, very often involving likelihood and impact as a typical risk equation, to give you a picture as to what risk looks like and what different threat events, the risk that they pose. And it will help you prioritize and make business-focused decisions around what we call risk treatment, which is around mitigating risk through increased protection, avoiding risk, maybe by even decommissioning a system if it's that important, by transferring risk in sometimes, by passing it off to someone else. That's fertile ground for lawyers. Or in some cases, just accepting the risk. The business might say, yeah, we're prepared to accept that. That's okay. Well, if they have done that, then you should look for evidence as to their rationale as to why they have accepted risk. So that's what a diligent approach to risk management looks like. One last point on suppliers and third parties. They can introduce hidden risk, particularly if there's information sharing going on through shared systems access. So you should look for an assurance process that has taken the supplier estate, if you like, seriously, to ensure the organization that you're looking at has assessed its supplier risk in line with the criticality of the potential exposure. And that's, again, something that we do a lot with organizations. Just, again, it helps organizations prioritize, because you can't subject every supplier to the same level of requirement from a cyber risk point of view. But the really important ones, you do need to look at them really closely and ensure the right protection is in place, because you want to shut that hidden back door as far as possible. Moving on a slide, and we're coming towards the close. So sorts of questions then that you might ask if you were representing Harry's Hardware in supporting due diligence activity. I'm not going to read through these, largely, and a lot of these are self-explanatory given the different topics we've just been talking to. Just to hone in on a few. Question 4, understanding an organization's cybersecurity maturity. Some large organizations will have their entire programs aligned with maturity concepts. But at least you need to be looking for indicators that an organization takes cyber seriously. Does the board address cyber risk as a matter of course? Has it historically translated that risk into a strategy that's fit for purpose? Is that strategy, and was it supported by fit for purpose policies that were communicated in an actionable way out to the business, and so on? There are key indicators that will show you that an organization has been diligent. Question 5 quickly. Strong baseline hygiene in cyber is really important, irrespective of that risk-based approach that I've just mentioned. And there are some good frameworks out there that can help you achieve that. Things like ISO 27001, the NIST cybersecurity framework, the standard of good practice from the Information Security Forum. They're really good, credible frameworks that help you put in place a structure. And if you've seen that your target acquisition and demand team has identified a structure that it's indicated an intent to align with it, that it's assessed against it, that it's worked out where it's deficient against it, that type of mature thinking is very good as an indicator when you're looking at a potential acquisition. And then very lastly, if we move to the next slide, we've got some final conclusions, points to take away. Again, I won't read these through, but just to reinforce, a mechanical approach to due diligence is very unlikely to unearth true underlying cyber risk. Risk assessment, it's all about pragmatism. It's about business risk. It's not just about IT. And putting an organization in a position where it can take decisions with confidence. M&A risk, it is likely to introduce cyber risk that might just not have been anticipated. Suppliers and third parties, they can present that hidden back door for cyber risk to wiggle its way into the organization. You need to look for evidence that that's been taken seriously. And there are tried-tested frameworks out there that can help demonstrate a responsible approach to cyber risk management. So those are the key messages that I wanted to share. I've sped up a little bit there because I'm conscious of the time, and we want to get some questions covered. So Simon, back over to you.
Simon, thank you very much. You did very well to get through a large, complex subject there in a short space of time. Just to reassure the audience, we will be sharing these slides with you, so don't be sit there scribbling away on your pen there to capture what Simon has put out there. We will be sharing those with you. I think Simon made a really good point there about business risk and IT. I have long held the view that actually cybersecurity risk is just business risk because the impact is on the business itself. Without any further ado, we have some questions here. Please send some more in if there's anything you'd like to ask. And thank you for these that have come through so far. So my question there is a link that we used, and I'll bring in Nick and Sharon if you're able to join us at this point too, regarding the threat question that I asked Howard. Is there effectively a legal wrapper around your risk management? And the question here is, how do you validate the cyber risk assessments done at the firm being acquired? I'm not quite sure would that go to Howard or Nick Frost? Nick sat there patiently waiting. Nick,
yeah, let me take that one, and maybe Sharon can add the sort of the legal side of things. So, okay, so how do you validate cyber risk assessments? That's a good question, because this term of a cyber risk assessment, we've seen quite a variety of what's called a cyber risk assessment. I think the point here is certainly you need to follow a structured process. If you are going to measure cyber risk, either qualitative or quantitative, you need to ensure you've got a fairly rigorous process. So it's those key stages that Simon highlighted before. You understand the potential impact. What does the consequences look like? What kind of threats do you think that particular maybe system, asset, or maybe the entire business in this case, is there a type of threat or threats that are polarized towards that particular asset. And then, you know, what have you got in place in terms of your ability to mitigate it? You know, there are lots of sort of tools and frameworks that can take that information together and come up with a, you know, a risk rating or a prioritized risk rating. I think the other point to add to this, that's what you get from your risk assessments, that, you know, the risk, the additional piece, if you like, the management piece is, well, how has that been mitigated? It's something we've seen quite a lot where organizations are very good at identifying and prioritizing those risks. But the hard part actually is actually addressing them. You know, how much money can be spent, what are the best controls, and how can you do this without causing huge amounts of disruption to the organization? So that's the kind of cyber view, if you like, to that question.
Well, just to add to that as well, you know, it's not a one-shot thing, risk assessment, because obviously the threat landscape shifts. So, you know, if a system is particularly critical to a business's success or survival, you would expect to see that that's at least revalidated over time and at stage points is reconducted. And there's something, it's not just about results of assessments themselves. It's looking for a mature approach and process, because if an organization has taken the step to say, we acknowledge that cyber risk is a thing, we know it's a business issue, we know we need to assess it, we will put in place a process to assess it over time and to revisit it over time, you know, there will be evidence that that approach exists, and that in itself is a really good sign, because you know, as I say, risk does change, it changes all the time. So you can't take confidence just with the risk assessment was done 2 years ago that covers you off. So it's more about an ongoing mentality and assurance that the organization, the target organization, has taken this really seriously and has applied a credible approach.
Thank you both there. And I have a question here from the audience. Should the purchaser carry out a data privacy impact assessment? If so, how do you do that? And I guess that's predominantly towards Harold, this question.
Yeah, well, arguably, the data protection impact assessment was carried out by controllers, where there's going to be a change in technology or significant changes in the data processing activities. So given the data, which I mean, it could be that both parties need to, we could have a separate webinar just on DPIAs, but the first transfer of data is going to be, the sharing of data initially is going to be handyman teams' personal data, that's say their customers, their staff, which almost certainly is going to be merged with the purchasers. So I think looking at it first from what the vendor should be doing, I mean, there's no reason why the purchaser couldn't do that, but the purchaser is not going to necessarily have access to the personal data because they're not the controller. So, but looking at what it is, when it's required pursuant to Article 35 of GDPR, it must happen prior to the new technology or the new data processing activities taking place. So if it's going to happen, legally it's going to happen before the merger. What are the objectives, what you're going to look at, and it's quite detailed, Article 35, happy to advise separately on it, but you've got to look at the objects of the change in processing. Well, here the object is it's going to be a merger of two companies. Looks at the types of data. It's very important because special category data, which includes, for instance, religious, political, but physical and mental health. Well, given what Andyman team do, it could well be that there is special category data because their customers, they could have a disabled customer, for instance, and on record that they've got that they were installing rails in the bathroom because somebody was disabled or visually impaired. So there could well be special category data, which will need to be looked at very seriously. What about where the data is processing? Well, if Harry's hardware, in fact, are processing outside the EU, for instance, so that Handyman team's personal data is suddenly going to be migrated outside the EU, then that's critically important to be looked at. By whom accessed? Well, who's going to look at it? You look at the benefit of the aims of the project. You build a risk register. It's a bit like the cyber risk. you look at a risk register, you look at the impact, the description of the risk, and you give it a risk rating. Often you'll seek the views of the data subjects. Not always practical, not always essential. It's where appropriate. If high risk, it's required if it's high risk, but if it's high risk, consult with the ICO. Consult with them rather than be chased by them when you should have done it and you shouldn't. But in a business that we're dealing with here, which is not, there's not millions of bits of personal data, I shouldn't think. There probably isn't going to be that much of a change given the types of business they are. I doubt whether there's massive technological change, but certainly you've got to look at the risks. And vis-a-vis employees, well, why not consult? It shouldn't be a secret subject to commercial sensitivity. So it's quite a detailed process. It's not always necessary. The questioner asked, should the purchaser be doing this? Well, if there's going to be a two-way sharing, or if after the merger there are going to be changes in the technologies for the purchaser as well, or changes in the types of processing, then they should too. But it's certainly incumbent upon both data controllers to see whether a DPI is necessary.
Okay. That's great, Howard. Sorry to cut across you a little bit. I'm just trying to get one more question if we can before the end, because I'll go ask one to Sharon, because Sharon hasn't said much yet. We haven't given an opportunity to. So question for you, Sharon, and don't worry if your question's not answered here, we will get back to you post-event. What can or should buyers do if they discover a problem during the due diligence? And again, I'm aware that we're kind of out of time, but if we can keep it fairly brief, that'd be great, Sharon, if you could just give us some frame on that.
Yes, I thought I might have managed to escape completely, but I will try and keep it nice and quick. If a purchaser finds something in the due diligence exercise that makes them uncomfortable, there are a number of responses. Firstly, they can ask for some more information, really drill down to try to get to the bottom of understanding what's the commercial impact of what they've found. They might seek additional warranties to back the more general ones that have flushed out this concern. They might seek a specific indemnity, and Howard has touched briefly on the difference between warranties and indemnities, but just to recap, a warranty is a statement that something is true. The disclosure then says this warranty is true except for this particular problem. It might say we are being investigated by the ICO. So your indemnity would then say that the seller must indemnify you, must compensate you if that investigation results in a fine. So you can be very specific. I have found this problem and this is why and how I want you, seller, to bear the cost of that problem if it comes home to roost. Ultimately, it's also open to the buyer at that stage to try and reduce the price to reflect the commercial risk that they will end up bearing. It may be possible to get warranty and indemnity insurance to cover against that risk. And ultimately, if it really is a significant problem and there's evidence that the seller hasn't turned their mind to the issue at all and taken it seriously, the buyer might want to think twice about whether this is a company which they actually do want to buy. So looking at it from the seller's point of view, when you're putting together your data room and compiling answers to the questionnaire, it's really important not just to dump information into the data room without thinking about it. You should read your own information first to be prepared for any of those questions, any of those pushbacks, and look to proactively solve the problem rather than leave it for the potential buyer to raise that with you when they will then be on the front foot in reducing the price or in some other way worsening the terms of the deal for you as the seller.
That's fantastic. Thank you very much, and thank you for being so concise on that there, Sharon. Thank you. I'm sure that's something you could talk about for some time. We're out of time now, unfortunately. There are a few more questions we didn't get round to addressing there, so apologies if we didn't ask your question. So just to wrap up today, firstly, I'd like to thank all the speakers for their knowledge and sharing their knowledge with us this afternoon, and for Sharon and Nick for being so patient then leaping into questions, the ones who were put on the spot there. So thank you very much for your time, guys. Also, thank you to the audience for tuning in today, and hope you've got something that we welcome feedback. So feel free to ping us an email and give us some feedback on the event today. And if there's anything else you'd like us to cover at a future webinar, please do that. The questions and the slides will follow, and we will send those on. We've had a couple of people asking for us to do that, and I guess the real takeaway here is please talk to us. We're happy to have an informal, quick communication with you. If there's something that's playing on your mind regarding anything you've mentioned in the webinar today. We are a normal bunch of people, although we may have caught you on the hop a little bit with that today. We're a normal bunch of people. We like to hear people. We like to hear from people. We like to have queries and questions come in. So please get in touch with us. If there's anything we can help you with. And I think you should have all our contact details anyway. But thanks very much for your time. I hope you've got plenty from this today, and hopefully we'll speak to you again soon. Thanks very much. Bye-bye.
Thank you, everyone.
Bye for now.
Bye, everyone.
Bye-bye.
Thank you. Bye-bye.